just about everybody. There might be a couple more kind of coming in at the last minute, as teams can be a little finicky sometimes. So I just, I guess I'll just start by introducing myself briefly. For those of you I haven't met, my name is Ashley Koirtyohann. I am a shareholder in the Frisco office in our POA section, board certified in Property Owners Association law. Been doing this for close to 10 years now, which is a little crazy. But I'm here today to talk to you about association contracts and master service agreements and kind of the key things to look out for and why it's important. I'm going to do my best to leave time at the end for questions. So we have a chat box, I believe, where you can submit any questions that you have. But I'll give the usual disclaimer first. So looks like we need to update that date. The information provided today is based on the laws as it exists today, which would be May 19th. The information presented is for educational purposes only, so it doesn't really constitute legal advice for your specific association. And if you do need advice about a contract that you're looking at or a dispute that you might have with a vendor that you've already entered into a contract with, you should consult the association's attorney on that. So this is going to be very kind of high-level generalized information. So we're going to talk about vendors and how contracts can serve in defining the relationship with the vendor and also helping to kind of transfer the risk from the association to the vendor whenever possible. The specifics of master services agreements, and then just a kind of primer on understanding insurance and indemnity and how those two concepts really work together. So the term for vendor for this presentation means any service provider. So your landscaper, your lifeguards, your construction contractors. And while the association, it also have vendors in the sense that it has a legal, it has attorneys, it has CPAs, it has bankers and insurance brokers. This is really focused more on that kind of first category. So people who are providing these on the ground services to the association. And this professional team is going to be more important in terms of kind of ironing out that contract once a vendor has been selected, because all of these people could potentially come into that equation. So when we talk about a master service agreement, this is a master service agreement is a large overarching contract that covers sort of any sort of work that gets done between a vendor and an association. So the master service agreement has all of the specifics about things like payment terms and insurance and indemnity and the term of the agreement and renewals and termination and all those sorts of general terms. And then under that master service agreement, you enter into different scopes of work. So, you might say this is the master service agreement is going to govern the relationship between these two parties. But whenever you're ready for them to do some specific work for the association, you have a scope of work that addresses that particular project. And then that scope of work is governed by the terms of the MSA, so that you don't have to enter into a new contract every time you're wanting the vendor to do something for the association. And so in terms of negotiating the agreement and MSA, the best thing you can do, kind of the easiest way to do it, if you know on the outset that you're going to be bidding out this project, is to have the association's attorney or in-house counsel for a management company potentially prepare a template contract for its vendors. And that way, when you send out the RFP, you can provide a copy of that template contract and say, this is what we're going to ask you to sign, subject to any sort of tweaking that needs to be done to make it fit the contractor's bid or to address the specific scope of work. And that way, everybody kind of knows up front the terms that they're going to be expected to agree to. And it can really streamline the process when you're going out and getting those bids, as opposed to selecting a contractor. They provide their bid or their proposed contract, and then we provide ours, and then it kind of turns into can become quite a protracted negotiation. So one of the things you can do is just provide that up front. And this is going to be the document that, again, addresses all of those kind of main big topics. So the terms of payment, the scope of the work being performed, at least for that first project, the insurance that the contractor is going to be required to carry, the indemnity provision that sets forth each party's, typically just the vendor's, indemnity obligations for any claims that arise out of work performed by the vendor. What constitutes a default, do the parties have a right to terminate and without cause? If it's with cause, how is that defined? What kind of notice is required? all of those really more administrative provisions. And then, a lot of those, the way that we drafted, at least for our clients, is obviously very favorable towards our client, whereas the vendor's agreement sometimes it's very favorable to the vendor. Sometimes it just doesn't address any of these issues at all. It might be like a quick little 2-pager that doesn't include any language about how to terminate the agreement, for example. So, we really want those terms to be laid out, so if there's ever a dispute about any of them, the contract really provides the language that we need to engage in that conversation. So here's a fun little question for everybody. Is a 5-page contract long enough to protect the association in the event of a contract dispute? And A, yes, as long as the print is really small. No, because B, no, because the contract should all at least be 10 pages long. C, it depends, or D, maybe, depending on the parties. The classic attorney answer is C, it depends. And if anybody was ever kind of wondering how that came to be, or the attorney's motto, when you're in law school, they'll give you these multiple choice questions where they'll say, technically 3 of these answers could be right. But depending on the specific issue, facts of the question, one is more right than the other. So that kind of gave us all PTSD, and now we always want to say it depends. So here I would say it depends. Most times the reality is that if everything goes perfectly, a 2-page contract could be fine because, you're never going to be arguing about any of it. But in the event that a contract dispute arises, you want these major things to be covered. It's possible, depending on the type of project, to cover that in 5 pages maybe, but I haven't drafted very many contracts that are fewer than 10. Usually once you add on an exhibit that addresses insurance, it ends up being longer than that. So for the most part, these really short contracts that are provided by the vendor tend to be missing kind of critical details. So terms, the first one is going to be, what's the start date? When is the work expected to be commenced? What is the term? And which could be something like, for a one-off project, it might be that the work is to be completed within, let's say, 6 months. Or a term could be if it's a type of MSA where they're performing services routinely, such as a landscaping vendor who's providing services over the course of a period of time, that period of time would be the term. So a lot of them are for a year or 2 years. And then the provision that sets forth the term will also talk about how that term renews if it does. So either it'll be drafted to where the term ends and the contract automatically expires. It can be drafted to say that when the term ends, it automatically renews month to month, or it automatically renews for, an identical length of time. So if it's a 1-year term, it renews for another year. Usually if there's any sort of auto renewal, the document will include a deadline by which either party can avoid that renewal. So usually it'll be, 30 or 60 days before the term expires, you send a notice to the other party saying we don't want to renew this contract. And that's how you avoid that auto renewal. So you do want, whenever you have a signed contract, you do want to be kind of cognizant of those deadlines and make sure that they're calendared so that oh, hey, if we decide that we want to bid this out to somebody else, we need to be sure to let them know by, I don't know, November 1st that we're not gonna renew the contract, and making sure that those are noted so that you can make sure that any notices get out when they need to. So the next big one is termination and default. This is, I would say, like the #1 provision that we see missing from vendor contracts, meaning contracts that are drafted by the vendor, is any sort of discussion of how the parties can terminate the agreement. So usually you can either terminate with cause or without cause, or both. With cause just meaning that something has happened, the other party has done something that kind of gives rise to the right of the other party to terminate. Without cause just means, you could up and decide one day, we don't want to work with this vendor anymore for no particular reason, and you can still terminate. With cause can even kind of further be broken into 2 categories. There's usually, the most common one would be the other party breaches the agreement. And a lot of times that will include an obligation to give the party that's in breach the opportunity to correct that breach. So it might require a notice to go out, and then they have 10 days to correct the violation, for example, or at that point, the other party can go ahead and terminate the agreement. And then a lot of ours will also include situations in which you can terminate for cause without any sort of notice for certain things. So that would be something like if the vendor files bankruptcy, you don't have to give them an opportunity to cure. You can just submit a notice of termination. So that's all going to be governed by the language of the contract itself. Default, again, the agreement should kind of provide a scope of what is considered to be a breach of the agreement or a default under the agreement. Is there a right to cure, at least for curable breaches? These are all things that are addressed within the text of the document itself. Miscellaneous items would be, does the vendor have a right to use subcontractors? Can they subcontract out any of the work? I would say for a construction project, it's almost guaranteed that the vendor is going to be subcontracting some of the work out. So in that case, if they're going to use subcontractors, we'll include language that says that we don't have to pay you until that you provide a release from your subcontractor saying that you paid them whatever they were owed out of the last payment that we gave you, for example. That's more of a construction specific issue. But that way, the association doesn't end up in a situation where it paid its primary contractor in full, only for them to kind of stiff their subs. And now the association is stuck dealing with a lien or a demand letter from subcontractor. And then also in the context of construction, defining actual completion versus substantial completion is something that you see in a lot of larger projects where once the work has been substantially completed, that's when the vendor and the association kind of walk through the project together, note any punch list items that need to be corrected, and then it's not considered fully completed until those items have been addressed. So these are all things that get addressed in the contract. Sort of what is that timeline? It can be a specific number of days from the start of, from the commencement of construction. It could be like a specific date deadline. There are a lot of different ways to do that. And then usually it accounts somewhere in there for delays due to things that are outside of the party's control. So weather, or, any sort of issues with obtaining materials, things like that. Payment terms should 100% should be included. If it's something like, let's say it's a landscaping agreement that says this is going to be your annual price, it should specify, is that broken into 12 equal monthly payments? Is it more in the summer when they're doing more work and less the rest of the year? If it's a pool contractor agreement, they probably want, especially if it's a lifeguard company, they're going to want most of those payments to occur during those summer months when the services are being provided. What is the deadline after an invoice is received to issue payment? For construction contracts, there's this concept called retainage that's intended to address that subcontractor issue I mentioned a few minutes ago, which means that statutorily, if the association enters into a construction contract, it should be withholding 10% of any payment that's due. And then after the work is completed and a certain amount of time has passed, 30 days, and if no subcontractors have made any claims against the retainage, then the association releases that 10% to the contractor. Or if a claim is made by a subcontractor during that period, the association's liability is limited to that 10% retainage. Who has to approve work for a progress payment? So if you have a construction agreement that says, that we're going to be, every month we'll invoice you for the work done in that month and the materials purchased in that month, designating kind of who's responsible for making sure that it's accurate, that the work was done, kind of up to snuff, and then who approves that payment. What happens with the payment that's due if, let's say, the work wasn't up to standard? Is there a right for the association to withhold all or part of a payment? That's typically something we like to include, is the opportunity to withhold at least part of a payment for work that doesn't comply with the contract. And then who's responsible for sales tax? This is really going to come into play more with our associations that are registered 501c4s. If the association has a tax exemption, we want to be sure that we address that in the payment terms. Indemnity is the big one. I'm sure everybody has heard something about this at some point. An indemnity provision essentially says that if a claim is brought against, in this case, the association, because of something the contractor did or something to do with the work the contractor performed, that the contractor has to pay the association's cost of defense, has to pay any damages that are awarded against the association, has to address any liens, all these things. It essentially says that, look, we're trusting you to do this work, So if you mess it up and we end up kind of in hot water because of it, then you're going to be on the hook for those costs and for any damages. It's really just like a liability shifting provision to say, look, instead of the association taking on this liability, we're shifting that to you. Indemnity provisions are highly technical provisions. They, there are certain guidelines about the size of the font compared to the font surrounding it. All of these kind of conspicuous notice requirements that have been adapted through case law over the years or through statutes. And so you definitely want an attorney to look at your indemnity provision, because it's even if you have all the exact words you're supposed to have, if they don't look the right way, it could be found unenforceable. It's all kind of crazy. So when you're looking at these indemnity provisions, who's accepting the risk related to performance? It's rare for a vendor to include an indemnity provision that favors the association, because it's not really in their best interest. So a lot of vendor agreements will either not address this at all. It'll have a mutual indemnity provision, which, depending on how it's worded, can effectively cancel itself out. So you do want to pay special attention to that, especially any sort of high risk contracts. So the highest risk would be things like lifeguards, would be construction agreements, would be security services, potentially landscaping, anything that has a risk of resulting in some sort of property damage or bodily harm. Those are going to be the major claims. Those are going to be the biggest claims you deal with. So just making sure that those are addressed. You want the indemnification to be funded by insurance. So most vendors are not going to have substantial assets that could be reached if the association gets a judgment against them. So Texas is a very judgment debtor friendly state. There's a lot of things that are excluded from collection to satisfy a judgment, but also, depending on how they structure their business, if it's an LLC, for example, it's not like you can go seize the personal property of the manager of that LLC. So you really want the insurance to be available to fund that indemnity obligation, because that's the vast majority of the time, that's what's actually going to be available. So we'll talk a little bit about insurance in a minute, but the main thing is to just be sure that both are addressed in the agreement and that they work together. And also that, the amount of insurance is sufficient to cover the association in the event of a claim. We like to include third-party language that talks about third-party claims. So somebody, who's not a party to the contract, like homeowner, for example, sues the vendor and the association, we like to include language that talks about, if a settlement is going to be reached between the contractor and the homeowner, including language that requires it to also include a release against the association, so that you don't end up in a situation where insurance is exhausted in a settlement between those two parties and the association is left holding the bag, because even though the association has this continuing right of indemnification against the contractor, if the contractor doesn't have the money, it's essentially worth the paper it's written on. You want to include language about the duty to defend. So this is, again, in most litigation that doesn't involve serious bodily injury, the most expensive line item is going to be attorney's fees. So making sure that that indemnity covers cost of defense. And then again, addresses, especially if there's going to be subcontractors, who's responsible for supervising the work, essentially saying that the contractor is responsible for claims arising not only out of their actions or inactions, but those of their subcontractors. You can also include, you can also include language addressing the quality and quantity of the work. So, this would really more typically be in like a warranty provision. Basically, if the work is completed and there's some sort of issue with it, what's the contractor's obligation to come back and correct? All right, so what is the purpose of an indemnity provision? A, so the indemnitor indemnifies the indemnity. B, to protect against third-party claims. C, to compensate a party for certain losses. Or D, all of the above. Give you a second to think about it. So it's going to be D. These are very comprehensive provisions, but essentially the overarching goal is to be sure that the association is not left in an unfavorable position in the event of a claim. So insurance requirements, again, insurance is going to be vital to make sure that that indemnity is fully funded. And these are issues that you're really going to work with the association's insurance broker or insurance professional on, because they honestly know more about some of these details than your attorneys will. So this will address not only the type of coverage that they're required to carry and in what levels, but also language that requires them to use carriers who are admitted in Texas. Carriers who have certain ratings to show that they're essentially reputable insurance companies, that that they pay out on claims that are valid. And then insurance limits, again, kind of trying to figure out what is that amount of coverage that you really need. So for something like a lifeguard contract, it's probably going to be a higher level of coverage that you would need than you would need for something like a landscaping contract, just because the likelihood of a catastrophic claim is higher in situations where you're dealing with lifeguards than when you're dealing with landscapers. And that's not to say that you couldn't have a serious injury involving a landscaping company. It's not as common. So really coordinating with the association's insurance broker to figure out what is the appropriate level of coverage we should require here. What is there some sort of unique type of coverage that we need for this particular type of contractor? For example, there are policies that relate specifically to the use of drones. So if you're using a construction company who's going to be using a drone for some reason, you might want that type of coverage, even though you wouldn't normally require it. And then just making sure you understand kind of the difference between a claims made policy versus occurrence policies. So some policies cover claims that are made, any claims that are asserted during the term of the policy, regardless of when kind of the action giving rise to the claim occurred. So basically, if you submit the claim to the carrier during the term of that policy, that's what they're looking at. And some cover claims that arise during the term of that policy. So making sure you understand the difference between two, so that if you switch from one to the other, you can ensure you have sort of a continuity of coverage. Or that, the contractor's coverage is continuous in the case of an indemnity obligation. And then just understanding depleting limits policies. So a lot of times it'll look great if a lifeguard company has, let's say, $5 million in insurance. But if they have, a claim in another association that results in either a catastrophic injury or death, very easy for that policy to get depleted, in which case if the association has a claim, even if it's a smaller claim, there might not be any insurance available at that point. So in a perfect world, these would be sort of per location policies, meaning that the pot of available insurance is only accessible by this association for work performed in this community. It's very hard to find these days, just because it's become cost prohibitive for a lot of vendors. So you're a lot of times it may be a situation where none of the vendors have perfect insurance that's going to cover everything that could ever happen. So you may be doing an apples to apples comparison where you say, well, this vendor costs a little more, but their insurance is better, and kind of working through that analysis to figure out, is it worth paying a little extra to have a vendor who has more insurance available in the event of a claim. So the most common types of insurance: general liability, workers' compensation. A lot of people will ask about workers' compensation, even if, let's say this is a single member LLC, workers' compensation could still apply. So workers' comp policies, commercial auto policies, especially if they're going to be operating vehicles on association property. So, those landscapers who bring trucks and trailers and things onto association property. Umbrella coverage is like a supplement to their general liability that provides kind of a greater range of coverage, or you could have an excess policy that covers the same types of claims, but provides an extra pot of money that's available if the general liability policy gets exhausted. Professional liability would come in if you're dealing with something like an engineer or an architect. Their professional liability policy is something that they want to look at for them. Pollution and cybercrime or fidelity insurance are less likely to come up. It's not something that we see frequently, but those, again, this is a situation where you'd want to talk to your broker and figure out if these are types of policies that you would want for the work being provided. And then, when a claim occurs, whose insurance pays first is the question that we want the contract to answer, and we want that answer to be the vendor's contract, or I'm sorry, the vendor's insurance, and not the association's insurance. And you still want to have that insurance available in case, again, the contractor's insurance gets exhausted for some reason, or they let their insurance lapse. You do still want the association to have coverage, but ideally, vendor's insurance company pays out that claim before it ever gets to the associations. Now, that doesn't mean you don't present the claim to the association's insurance. It's very important. I'm sure everybody's heard this at some point, but if a claim isn't tendered timely, the carrier could deny it later. So, even if the association's insurance hopefully won't have to pay anything out, when a claim is submitted to the vendor's insurance, you should also go ahead and submit it to the associations. Okay, so we're going to just look at a sample certificate of insurance and kind of go through what it talks about. For this particular one, this is like the top of the page, and where, we blacked it out because this is one that we actually used, or one that we reviewed for a client at one point, but this box over here where it says insured, I don't know if y'all can see my cursor. That is where you would want to make sure that this is the name of the vendor. One of the first things we do when we get a contract to look at for a client is make sure that both the vendor and the association are properly named in the agreement, because a lot of vendors will use either like a DBA or some shortened version of their name, and we want to make sure that they're identified both on the COI and in the agreement by their full legal name as it's registered with the Texas Secretary of State. So that'll have the insured listed here in this bottom left box. And we want that to match however we identify the contractor in the agreement. And then it'll provide over on the right the list of insurance companies that provide coverage under the COI. This date up in the right corner is something you want to pay attention to as well. If it's an old copy, you want something that's up to date to make sure that it includes coverage for the period that you're in right now. So in this case, we'll start under this box B that talks about the type of insurance. In this case, the first box is, and usually the first box will be general liability insurance. It'll address the amount of the deductible. It'll talk about, is this a per project coverage or per location? So per location is that sort of unicorn that we love, but we never see. And then is it a claims made or an occurrence policy? So in this case, general liability per occurrence, occurrence policy, $25,000 deductible, and it's going to be that per project rather than per location, meaning that really anybody the vendor works with could potentially reach this insurance. The policy number is important if you ever need to make a claim, and then also the effective date and the expiration. So this policy started on May 7th, 2020, expired on May 1st, 2021. This limits on the right-hand side will break that coverage down into the amount available for certain types of claims. So for each occurrence, it's up to, the limit is $1 million. If it's damage to damage to a rented premises, it's going to be $100,000. Personal and advertising injury, $1 million, and the general aggregate is $2 million, which means if you have a claim, the absolute most you'd ever get paid out was $1 million. And then if let's say that the contractor has two claims for a total of $1 million, that will wipe out their insurance. So general aggregate is the total amount they'll pay out for multiple claims, but each occurrence is what you'll have available for a single claim. So, auto liability, same thing. Does it include autos that aren't owned by the company? Does it include hired autos? What $1 million is typically what you see for commercial auto coverage. That's nothing unusual. And in this case, under D, the contractor carries excess liability. It's a per occurrence policy, but this essentially means that, let's say this $2 million up in the general liability gets exhausted by multiple claims. They also have a $2 million excess policy that could potentially kick in. So again, you want to look at the dates, figure out, make sure it's still in effect. If they hand you a COI where the policy expiration period is already passed, make sure you're asking for an updated one. And then workers' compensation, it looks like here they do not carry workers' compensation. Or no, I'm sorry, they do. They do carry workers' compensation per the statute, which is a $1 million policy. That's the most common that you'll see because that's what Texas law requires you to cover. I'm sorry, to carry. I don't know. There's some interesting things about workers' compensation that I guess is more important for the other side, for the vendor. So I won't get into the details. I just find it kind of fascinating. If there are any sort of additional kind of add-ons to the policy, any sort of riders that provide either exclusions from coverage or add-in coverage that would typically be covered by the policy, those will all be down in this bottom box where it says description of operations, locations, vehicles, additional remarks. So this number off to the side, let's say the blanket additional insured form, and then it gives you the form number. You can use that form number to look up what the language actually says, but it's usually a pretty dry read. I would refer to your insurance broker for that. But this includes any sort of, they have their base policy. If there are any sort of modifications to the policy, those will be listed down in here. And then, the certificate holder, authorized representative, this is just so you can verify that the parties are listed correctly. There should be an additional insured box on here, and that's where you want to make sure that the association is listed. We typically include management companies and indemnity provisions as well, so you can try to make sure that both the association and the management company are listed by their legal names to make sure that they're listed as an additional insured, essentially somebody who has the benefit of the coverage. All right. So the association is, I might have given the answer away. The association is listed as a certificate holder on the COI. Does this mean the association is an additional insured under the contract? Yes, as long as the contract requires the association to be named as an additional insured. No, a certificate holder only entitles the association to receive a copy of the COI. C, it depends on what the contract says. And D, what's a COI? So COI, to answer D, certificate of insurance. But you do also want to be listed as specifically as an additional insured. It's better to be listed in the certificate holder than to not be listed at all, but you really want the additional insurance status to be spelled out pretty clearly. All right, so I wanted to make sure we had time for questions because I know this is the time of year where people are entering into landscaping or pool contracts or whatever the case may be. So I'm gonna exit out of here real quick so that I can see your questions. But if you want to tell us how we're doing, leave us a Google review if we provide services for you or anything like that. You can scan the QR code and that'll take you to a place where you can do that. And then I think I'm going to go to the next slide just so if anybody needs my contact information because they come up with a question after the webinar ends, which is what always happens to me. I think of a great question as soon as something ends. You can scan this QR code and it'll download my information for you. I'm in our Frisco office, but we have these other offices in Austin, Houston, and San Antonio, and we serve clients all over the state. So let me stop sharing that and look at questions. Okay. All right. Okay, so I'm just going to start at the top. Stacy McGrath asked, can a clause be included stating that if the work is not completed by a specified date, a daily fee may be charged until the service is fully completed? Potentially, yes. I'm not aware of anything that would prohibit that outright. There is this concept in contracting about, liquidated damages, which is essentially, any sort of damage that's tied to a specific cost. And so we want it to be reasonable in the sense that it's, at least drafted to say that it's an estimate of what the association's out-of-pocket costs would be in the event that the work isn't completed in time, so that it's not considered strictly punitive in nature. But I don't see why something like that couldn't be drafted as long as it's drafted somewhat carefully. Nathan has a question. During negotiations, are you allowed to ask if the vendor has any current claims underway to determine if their general aggregate would still cover for your project? Yeah, you can absolutely ask. They're not required to tell you, but if they say we're not going to tell you, that's usually, I don't want to make any assumptions, but that's probably not a great sign. So you could decide what you want to do with that information, but you can ask for any of that information. There's nothing that would prevent you from doing that. Okay. Matthew asked, I'm in a high rise and just curious how many of the attendees require vendors to have workers' comp prior to a vendor doing work on the property. That might be a question for if anybody wants to chime in the chat. We usually recommend it. I will say it's not uncommon to see very small vendors who don't carry workers' comp insurance, but we do prefer to see it. Doesn't the property have the ability to reject a workers' comp waiver from the state? Yeah, so, the association doesn't have to accept a workers' compensation waiver. It can choose to go with a different vendor for, essentially any reason. Workers' comp, again, well, I'll just get into it briefly. Workers' comp is important because if you're the insured, so the contractor, and you don't carry workers' compensation, you are prohibited from putting on certain affirmative defenses if you get sued for a workplace injury, which is, I know a lot of legalese, but essentially, when somebody gets sued, you have the right to say, even if what they're saying is true, we're not liable because XYZ. That's considered an affirmative defense. And there are certain ones that you're not allowed to present in court if you don't carry workers' compensation. So it's really is more important for the vendor. But our strong preference is to see workers' compensation for anybody performing work for the association. Let's see, if property owners who are not members of an official POA committee perform work for the association. Oh, sorry, I lost my spot. If property owners who are not members of an official POA committee perform work for the association and that work otherwise have required the POA to hire a third party, should the board formally approve, document, and disclose that arrangement, including any oversight, liability, insurance, or conflict of interest considerations? Yes, I think that would be the safest thing to do. Even if, well, it's not really covered by the open meeting statute because it's not approving any expense, I guess, but especially any sort of conflict of interest, we really prefer not to see associations working with people who live in the community. It just can get kind of ugly if there's any sort of dispute. But the association, I would start by saying that if it's going to be a community member providing work for the association, I would start by making sure that any sort of claim, if they're injured in the process of performing that work, is the association's insurance going to cover that? Because if they're not bringing their own insurance to the table, that means you're going to be relying solely on the associations. And so making sure that the work of a member of the community is something that if it results in a claim would be covered by the association's own insurance. One of the reasons we like using third-party vendors is just because it gives you this opportunity to shift that liability in a way that you might not get in that particular context. And then Rachel Salazar is asking can we get a copy of this? I know the video, I think Kyle can correct me if I'm wrong, gets posted on our YouTube. I don't know if the slides, is there a way to send the slides out, Kyle?
Hey, Ashley, yeah, the video will be posted on our YouTube and the slides will email out.
Okay, perfect. Alrighty. Greg asked, we're dealing with a landscaper that has termination language that allows for termination for cause. We believe we have proven cause and have given the company the required 30 days to remedy the issue. The company is declining our termination, stating we have not proven cause, and we will have to pay the remaining contract if we cancel. In your opinion, will we have to go to court to fight paying the balance of the contractors, or another recommendation to avoid court? The first, if you haven't already, would be to just get the association's attorney involved. And, sometimes you can just start with a demand letter, and that might either trigger their insurance or it might result in kind of a shift in the dialogue if they know an attorney is involved. For really costly contracts, like this is like a lot of money at issue, you could say, like, let's agree to do, if dispute resolution isn't addressed in the contract, the parties could agree to mediate, to say, like, look, it's really not in anybody's benefit to spend a bunch of money litigating this. Why don't we agree to mediate and see if that's beneficial? But short of that, if neither of those are working, I would discuss your other options with your attorney in terms of filing suit or waiting for them to file suit. Should we include mediation, arbitration, negotiation provisions, or is that considered implicit because the court would likely direct a dispute that way? A lot of courts do require mediation. It's not universal, though. I like giving the parties the option to do these things. Mediation, sometimes you can tell on the nature of a dispute that it's not going to settle at mediation. And so sometimes that can be kind of a waste of time and money, but I do like the option for the parties to mediate. Arbitration is kind of in lieu of trial. So that's instead of taking it to a court, you go before an arbitrator. It used to be a really great option to settle disputes quickly and less expensively. That's not necessarily the case these days. Arbitrators have gotten quite expensive and the process has gotten quite long in a lot of cases. So we don't typically include arbitration provisions just because we don't find it beneficial to our client most of the time. But yeah, so if you were going to have an ADR provision, alternative dispute resolution, we would typically start with something like an informal negotiation period where one party can send the other kind of notice of a dispute, and then they meet informally to discuss it and see if they can work it out. And then if that doesn't work, you can move to mediation, and if that doesn't work, you can move to filing a lawsuit. Okay, follow-up question from Matthew. Can a board include in their documents a requirement for any vendor working for the HOA or one of our residents? Remember, we are a high-rise, be required to have workers' compensation. I think that's, for a high-rise, I think so. I mean, there's certainly an interest in a high-rise because vendors aren't necessarily coming into contact with the common elements that the association maintains. To kind of put those in place, it would need to be a formally adopted policy, ideally that's recorded. Well, not ideally, it should be a formal recorded policy. And then you just want to be sure that you're imposing it uniformly and requiring that information potentially like as part of an ACC application, for example. Definitely for any vendor working for the HOA, we want to see workers' compensation if they're going to be on association property. And then Angela is asking, can they increase on a contract if there's no language in the contract? So I'm assuming this is referring to like annual increases in the contract price. If there's nothing in the contract that discusses that, then arguably, no, they don't have the right to do that. So this is, a lot of termination provisions will say something like, renewal provisions will say that this is going to renew annually and there's going to be, a certain percentage increase to account for increased costs. If that's in there, then yes, they can do that. But generally, they don't have a right unless the contract addresses it to kind of unilaterally increase pricing. And then Crystal said surcharges for fuel. The same thing. Anything that either party is going to do really needs to be authorized by the agreement. So if they're going to charge you extra for fuel, or they're going to increase for increased expenses, that really needs to be addressed in the contract. And to the other side of that coin is, and I should have mentioned this, is that if the association, the main thing the association wants to do, especially like with respect to the scope of work, is to make sure that everything you want that vendor to do is included in that scope of work, so that when you come back and say, hey, you didn't do this, they don't have the option to say, well, we're not required to. So you really, they want to be sure on their side that all of their needs in terms of pricing are addressed, and the association wants to make sure that everything it expects the contractor to do is somewhere in that agreement. Let's see. We have a contract that says the association can bring in a consultant to audit the machinery and contract and provide the company a 30-day cure period before termination, but the board does the consultation themselves based on repair and ticket history. Can the company reject the notice? Without seeing the exact language, that'd really be something to reach out to the association's attorney about. But if it's worded to allow them to bring in like a third-party consultant, that could potentially be an issue. I would go to your association's attorney, provide them with that contract, and have them weigh in on that. Chris is asking, does the title of the contract actually matter? Does the selected wording of the title invoke any specific obligations? Titles, are really more informative than anything else. A lot of times, the contract might just be called like independent contractor agreement, something vague like that. We typically include in our boilerplate language, which is the kind of all the miscellaneous provisions at the end of the agreement, things about venue and which state's law controls and stuff like that. We'll usually include a provision that essentially says that the section headings are informational only, and if that really it's the body of the agreement that matters. And so, you know, a lot of times a court might depend on the headings to kind of deal with any ambiguities in the contract, but for the most part, they're not going to be as important as the actual language of the provisions underneath. If a contract has workers' compensation and they use a subcontractor, does the subcontractor need workers' compensation, or is that under the general contractor's responsibility? Usually we include language in the contract that says, you know, the vendor is responsible for making sure that their subcontractors meet the obligations for insurance that are laid out in the agreement itself. It's going to be very hard to keep track of what a subcontractor is doing. Ideally, the subcontractor would have their own workers' comp insurance, but it's going to be really hard for the association to keep track of that. Let's see. And if there's an indemnity provision like the one that we include in ours, if there were some sort of claim by a subcontractor that wouldn't be covered by their own workers' compensation, then the indemnity would kick in and still require that general contractor to cover that claim. Okay. When the MSA calls for an independent inspection, should independent reasonably mean independent from the contractor who performed the work, rather than allowing the contractor to inspect or validate its own work? I would say yes. I mean, there's really not a lot of benefit to having a contractor inspect their own work for the most part. So, independent inspection, you know, without seeing the provision, my guess would be that is generally referring to an independent third party. So, you know, not the association and not the contractor. And I think that's the last question I see. Nathan, it looks like you might have your hand raised. If you had a question that wasn't in the chat, you should be able to unmute yourself, I think, and ask. Can they do that, Kyle? Is there a way to? Oh, here, I'm hitting allow mic. Okay. Oh, hand went down, so we might have covered it. Okay, that's the last question I had. And again, my contact information, I can share it one more time real quick. If you, a little behind the scenes, because I don't have this pulled up, but this QR code right here, I think oh, that's all the way at the beginning, never mind. This QR code right here will provide my contact information. Also, if you just go to our website, rmwbh.com, we have a contact form you can use to reach me as well. So if you think of anything, please feel free to reach out. I really appreciate everybody taking the time out of their day-to-day to be here. And, you know, I look forward to speaking with you all again soon. Thanks.